Make please, your lordship.
Yes.
My lord, I beg to mention an IA for bail, lordship, for consideration of bail, criminal appeal matter, lordship.
What city?
No, lordship, regular bail, he is in
Regular
jail,
bail.
lordship.
He's in jail.
Lordship. I pray, lordship,
He's convicted.
convicted under section 3.
An application for suspension of the sentence.
Yes, lordship, we already, my appeal, application for IA bail pending, lordship. So I pray, lordship, this matter may come on Wednesday, lordship, if possible.
Wednesday.
March of lordship.
May it please your lordship, similar prayer on Thursday, lordship. Oblige your lordship.
My please, lordship. Yes, I'm praying for listing one IA lordship. Last time it was listed on 10/1/2024 before your lordship. But may be listed lordship.
When?
But
When? When do you want? When do you want it?
on lordship,
28, 29, when do you want? Tomorrow, day after tomorrow, when do you want?
lordship, any date lordship. Any date.
Give a date.
May I please, your lordship. Lordship, in this case, lordship, the appellant was convicted under section 302.
As
For-
Mr.
Ayush Chaudhary, lord.
Ayush Chaudhary, learned counsel for the appellant, who submits that the appellant was convicted by the Sessions Judge Lakhimpur in Sessions case number 73 bracket NL 2019 under section 02 IPC. Admit the appeal, call for the PCR. Ms. A. Begum accept notice on behalf of the state. This is the matter after 4 weeks.
IA is there, lordship.
There is no IA. IA is not on record. He's not in the column.
Lordship, deputy of lord.
Or not been listed.
Item 2 for orders.
Lordship, item 2, lordship, lordship, may peruse the last order, lordship,
Yeah,
2011,
DNA profiling was directed
lordship.
to be done as of state records.
So it has been apparently done, I think. I saw something somewhere.
Blood samples were collected, lordship, on 31/7/24.
There is an order which says that blood samples were collected, but a report not received. Lordship.
There was some kind of something I had seen somewhere.
Yes, that shows that that order is there, and which says, Lordship, that blood samples of victim
There
child.
is an 8/11/24 something. 8/11/24.
31/7 order.
No. That's all.
Connect.
31/7 is the order by the session judge.
Yes, which shows that blood samples were collected.
No. Subsequent to this, is there any other file? No.
No.
I assume it.
Wait, I saw something. Wait. Huh? There was something I had seen.
No, this is on side. I know.
Hey, show me the PCR. It will be there. Yes, you see this, there is this report from the Directorate of Forensic Science, 8/11/2024. It says here to the Superintendent of Police, Bongaigaon, Assam, your memo says advising examination of one parcel, so, one seal vial containing liquid blood of Sulabia Harijan, collected by Dr. Bongaigaon Civil Hospital with sensor. Another is of Priya Sutradhar, collected by sensor. And one is of Sudeep Biswas. Okay. Now,
So this one is the appellant.
the appellant.
Yes.
So it says here, result of the DNA fingerprinting analysis. And the DNA profiling had been directed to be done in, I think, 23 or something like that.
Yes.
Correct. Now this is of 24 November. So it says here, DNA from sources sensor. I do not know what it really means. I think it has been done. That's all.
May I please, Lordship? Here, my lord, is now for service, my lord. It has been complete, my lord, 29/8, this note, my lord.
Okay, so what about it now?
POSCO case, my lord, so,
So
amicus,
so there is the IA is there. What have you got to say? IA.
in the IA also, the amicus has to be heard, my lord.
Not required. Not required.
It,
If we are of the view that you have got no case made out for bail.
because as per the Diplomat judgment, my lord, any three.
No, but in the case that if it's going to be, when we are of the view that there's no grounds made out for bail, where's the question?
My lord, but then I have to place the evidence, my lord, I have to make a compilation on that, my lord.
No, you can say this is a prima facie case or not. It's under 430 BNSS, the POXO case.
389 earlier, my lord.
Maybe
Yes, my lord.
89, 430. Section 20B2B. 20B2B
Lots
slash 25.
two C, 25 and 29.
2C, 20B2C. Commercial quantity.
On lordship commercial
20B2C,
Hmm.
comma 25,
29.
comma 29 NDPS Act. Ms. R. Begum submits that she has got no objection to the delay being condoned. Accordingly, the delay is condoned. Registry to list the appeal. I is accordingly disposed of.
All right.
May I please, your lordship, my lord? My lord, this IA is filed for my lord.
5 days.
45 days, my lord.
So we issue notice.
My lord.
Have you deposited the
Yes, my lord.
arrear maintenance?
My lord, as per the last order, that area has been deposited, my lord.
When?
My lord,
Yes.
Wait, please, Your Worship. One of the applicants before your lordship,
Yes.
one is the judicial member of the income tax appeal tribunal, and another one is the accountant member of the income tax appeal tribunal.
Yes.
Well, the prayer is for expunging the adverse remarks made in the judgment.
Which portion of the
Well, I will just
remark?
say it for your lordship, my lord. At page 86, your lordship, let's see. And the revenue posted at page 107. (107), the last part.
Yes. How is this stigmatic?
No, your lordship, my lord.
This is what it has found, depending upon the thing.
My lord, I will just submit your lordship,
Yes.
my kindly see, my lord. Your lordship has to see that in what context, my lord, these observations have been made.
Ah,
My lord, the income tax appeal was heard by the income tax appellate tribunal. And the income tax appellate tribunal came to the conclusion that the explanation to rule section 14A is clarificatory and thereby retrospective in operation. And thereby the appeal of the SSC was dismissed.
no, that was made when?
My lord,
Which order? On the basis of which order?
the tribunal passed the order, my lord, on the appeal filed by the, my lord, the revenue,
Ah.
and the revenue appeal.
When did the tribunal pass the order?
Well, the tribunal passed the order. You'll also find page on 6/7/2022 at page 20.
Yes.
Now, after the decision was of the tribunal, my lord, there was a Delhi High Court decision dated 16/7/2022,
Yes.
whereby, my lord, it was held that extension to section 14A is not clarificatory and thereby it will be prospective in nature.
Yes.
Now, after the decision of the Delhi High Court, an income tax appeal came up of some other SSC before the tribunal.
What is that? What is that income tax appeal?
My lord, income tax appeal, I will give the copy, my lord. Copy दिया ना? अरे भाई यार, अच्छे से दिया ना?
No, it is here at para 7, page 9.
Well, it is mentioned there. But the copy of the order was not there. I've got the copy of the order. no? And the tribunal, my lord, by following the Delhi High Court decision, decided the case in favor of the SSC.
Why order dated?
My lord, this is order dated 3/9/11/2022.
Yes.
Now, my lord, after the
What is this Delhi High Court okay, This. So it followed the Delhi High Court decision.
decision, my lord.
Correct.
Subsequently, my lord, the SSC, of whose appeal was dismissed earlier prior to the decision of the Delhi High Court, filed an application before the tribunal for rectification of the mistake apparent from the face of the record.
Review.
Not review, there is no power of review, my lord. Rectification of the mistake apparent from the records on the basis that the Delhi High Court has given a decision.
Correct.
Now, the tribunal held, my lord, that the rectification power cannot be exercised.
Let's ensure that it is okay. I hope she might be hurt. She's okay. Okay.
Nowadays, small tribunal of the fracture.
No.
Well, the tribunal held, my lord, that as per the decision of the apex court, only when there is a jurisdictional high court or the Supreme Court decision is there, it can be said that there is a mistake apparent from the face of the record. Since the Delhi High Court decision is not a jurisdictional high court and the Supreme Court, it cannot be said to be mistake apparent from the face of the court, and thereby power of rectification cannot be exercised. The tribunal said that in a phrase case,
The power of rectification.
my lord,
Does not have the power to rectify.
because I will place before the the judgment of the apex court, where he said, my lord, only when the jurisdictional high court or Supreme Court decision is there, then only the power of rectification can be exercised. But the tribunal came to conclusion in a phrase case, the tribunal may do it, but the power of rectification of the mistake is not there. Now, on the basis, my lord, that in the earlier order, in a phrase case, the tribunal has decided the case in favor of the SSC by following the Delhi High Court, but in the rectification order, the tribunal has not followed it. The observations have been made. Now, if this is, my lord, in this way it is observed, then all the rectification cases where the appeal has been disposed of, one High Court decision comes, which is not, my lord, jurisdictional High Court nor Supreme Court. The people will file the rectification and petition and the order.
But one thing is, did you make a challenge to the 6/7/20 to this order to the 6/7/22 order before before any court.
No, 6/7/22 order was against the SSC. SSC came up before the appeal.
Okay, 6/7/22 was the order passed by the tribunal,
Tribunal.
which allowed the appeal. Of
Well,
the,
allow the appeal.
allowed the appeal.
My lord.
Now, then the SSC, then thereafter filed a rectification application pursuant to the Delhi High Court order. And where is so this page 107 is the result of that order.
My lord, 107, or which order, my lord?
107 is the result of the rectification order.
My lord,
Rectification order was dismissed. Basically, application was dismissed.
dismissed.
So they came to this court.
No, they came to this court challenging the original order, but along with the rectification.
Along with the rectification.
One appeal was against the rectification.
So now now what has happened is this court has probably set aside that order.
Yes, there's no problem for that.
6/7/22 has been set aside. So now if we go into whether consistency this view, now you against that order, this order will have to be challenged before the Supreme Court.
No, my lord, I'm not challenging the order. I'm not challenging the order, my lord, here. The merit, whatever has been decided, I have no problem at all, my lord. I'm not come up against the order. I am only, my lord, against the 4 lines because after all, my lord,
But would it amount to if we interfere with this part of the order, would it amount to saying that the finding of the tribunal was correct?
No, my lord, the finding of the tribunal, finding of the tribunal has been reversed by the High Court.
Correct.
There is no dispute about it, my lord. I'm not at all, my lord, on the finding merit. Finding has been already reversed. This is only an observation which has been made that the conduct of the tribunal members. Your Lordship, can you see, my lord? 107, no? What 107, my lord? I go to 86. At 107.
And if they don't have any power of and in the meantime, in another with the Delhi High Court at the same time with the have allowed to feel it was other
My Lordship, I kindly appreciate, my lord. I
understand.
am a judicial member of the accountant member of the tribunal, and any observations of my lord which says my lord the conduct of the members of the tribunal will be the High Court, my lord. My lord, it affects my lord the future prospects, my lord, because after all, my lord, I have not done anything, something illegal, my lord. I am based on the decision of the Supreme Court that you don't have the power to rectify on the basis of an order which is not jurisdiction of Supreme Court. How I can rectify the mistake, my lord? Otherwise, my lord, it will be on my lord.
It was maybe a wrong understanding, but so you see,
You also just read para 22, my lord, at page 106, my lord.
Yes.
My lord. We have also taken note of the fact that the bench of the tribunal, in its earlier decision dated so-and-so, rendered in so-and-so, while relying on the decision of the Delhi High Court in so-and-so, has held that the explanation inserted by section so-and-so is applicable prospectively. However, the same bench, while deciding the miscellaneous application, preferred by on behalf of the appellant subsequently, has concluded the decision of the Delhi High Court is not binding on the tribunal. Having taken note of so-and-so, my lord, the tribunal said that as per the Supreme Court decision, I will place before last the Supreme Court decision. The Supreme Court decision said that rectification power can be exercised only when there is a decision of the jurisdictional High Court or the Supreme Court.
No, we are okay with the, you see, the problem is, we understand your, that you want this part of the, remarks, it's fine, the last part. But the fact remains that it was the understanding of this court, maybe a wrong understanding.
Well, but
It was not stigmatic as such,
Well,
it was because of a wrong
one
understanding.
line from your lordship, my lord, it affects the judicial career of the accountant members of the tribunal, my lord, the judicial members. What it says, my lord, the members.
Would it amount to interfering in the merits of the case? That is what we're worried about.
No, my lord, not interfering at all. My lord, the merit of the case.
Because you see, it would amount to interfering with the merits of the case. For the simple reason that as per the decision of the Supreme Court that they are going to rely upon,
My lord.
we would be reverting back to the decision made by the tribunal and saying that it was correct.
No,
view.
my lord, no. I'm not saying, my lord, because
That would be the
they have
natural.
come up with the, you know, the original order, which was by which the appeal was, department was allowed, that has been reversed.
No. You see, the thing is this: the tribunal order of 6/7/22, according to your submission and according to the Supreme Court judgment that you are going to produce, was correct. Correct. But that has been reversed by this court.
No, my lord,
Only it has been reversed.
no, my lord, the order which has been reversed is the original order, my lord. This was a rectification application which has been dismissed.
No, but this rectification of that is of the order of 6/7/22.
My lord, the order which has been rectification has been dismissed.
Ah.
So the question is, my lord, the main appeal. The main appeal has been decided in favor of the SSC.
But you see, but that 6/7/22 order has been set aside or not? By
Your lordship, can you see, my lord? At your lordship, just similar, para 21.
21 years. Yes, it is set aside.
Now, consequently, we allow the present appeals, the impugned order dated 6/7/2020 passed by the tribunal in so-and-so is set aside and the order passed by so-and-so as confirmed. But it is the original order. The original order has been set aside, my lord. My lord.
No, it is. This correct. This is something. Made by the revenue.
The rectification appeal, the effect of the appeal. No? The rectification of the appeal is the effect of appeal. It is. Infection is not. So now it's up to the CF.
Go into that, I'm going to that.
No, last thing, kindly, my lord. At page 106, para 22.
They can take it up before the Supreme Court.
Para 20, last thing, see, my lord.
Yes,
At page 106.
yes.
In view of the aforesaid decision, the substantial question of law framed in these appeals are answered as follow. 1 and 2, these were the substantial question of law.
I think the best is you go to Supreme.
My lord, your lordship.
Otherwise, what we are scared is we might be
My lord, when
in
the
turn
question,
affecting the merits of the case.
my lord, when the question
Again.
was not there of rectification, your lordship may make it clear that your lordship is not at all making anything interfering with the merits of the case, only of the observations against the members. I'm not saying that your lordship may see the question is not there. The two questions which have been answered, there is nothing about rectification.
No, we do, because the thing is that you might be having a case on merits.
I'm not saying merit, my lord.
But then if we now interfere with this observation here,
I'm saying, my lord,
we do not know. You can take.
My
We
lord-
do not know what will happen in the next.
no, my lord, the
You say
question that, my lord, if your lordship, my lord, subject to qualification, my lord, if these observations have been, what a submission is that only the adverse remark made against the members. I'm not on the merits of the case at all. And your lordship may make it very clear that the merits of the case, whatever the case is there, that has not been either assailed nor will have any effect of your lordship's order. I'm not at all, my lord, why I should be grievance with the merits of the case. The tribunal member will cannot have any grievance about the merits of the case. And that was not the substantial question of law in the appeal at all. The question of law only, your lordship, see the two questions which have been answered by para 20, my lord. There is nothing about the rectification. In fact, the rectification appeal has been decided to be infructuous, my learned friend will say. After this order, the rectification, whatever appeal has been filed, the court said it is infructuous now. Nothing. Because the main case has been decided in favor of the SSC. There is no question of the rectification order, my lord. And your lordship, my lord, when the rectification is allowed, then it is merged. When rectification is dismissed, the question of merger does not arise. I am not at all, my lordship may in so many words may make it clear that not at all. I am not concerned, my lord, how the tribunal member can be concerned on the merits of the case. I am concerned only on my personal, my lord, the career which is there. One line of your lordship, my lord, against me makes, my lord, not at all, my lord, on the merits, how a tribunal member can file an appeal. Only, my lord, the remarks which have been made, the conduct of members, only that much. And your lordship may make it absolutely clear. My submission also may be recorded. There nothing on merit.
So you want only the last sentence.
My lord, you see the two lines, my lord, that we can only say that the conduct of the members of an authority which is discharging judicial members cannot be appreciated. Lordship will see the
Cannot be appreciated is neither here nor there. Not
Lord,
schematic.
your lordship will see any authority, my lord, your lordship, it is neither here, there, my lord, but when my case is considered for future, my lord.
You see, we also say that we do not appreciate the findings of the learned trial court and some
My lord, the finding of the trial court, whenever your lordship makes an observation against anyone, and your lordship will see it says that ourselves
You
from
see,
the
there are words
the conduct of the
where we say that
members.
that the finding is perverse. All those
Lordship will
things.
see this is not tribunal, my lord, this is conduct of the members. This is personal.
Well, yes, anything to say, Mr. Counsel? Let us say.
Okay, we are only for them allowed pro forma respondent number 2 and 3.
Who is 2 and 3?
That is income tax department. We have nothing to submit.
This is only, my lord.
Actually, notice has not been issued or what?
No.
What is this? Huh?
No, my lord.
For expunging of the remarks, adverse remarks, normally, my lord, Other party is not heard at all.
No, we should hear this.
Your lordship wants to hear, your lordship may hear.
You see, we understand your anxiety. Only
Well,
problem
I can
is,
appreciate, my lord, when your lordship says the trial court was not justified and all those things. But when the court says, my lord, the conduct of the members, my lord, it has a far-reaching effect on me, my lord.
but you could have gone to the Supreme Court, clarified everything.
My lord, when I have.
No, because because as per your submission, you are basically saying that the decision of the tribunal was correct.
I'm not saying, my lord, my conduct,
But
I'm
the-
saying. I'm
No,
saying,
because now what has happened is that as per the Supreme Court decision that you're relying upon, a rectification of an order can only be done on the basis of a jurisdictional high court or the Supreme Court. That not having been done, the tribunal was justified in rejecting the rectification application. No, that is what it comes to, basically.
my lord.
But the High Court, we had set aside the order of the tribunal.
Not second part, my lord, first part.
No, whatever.
The first order, my lord.
That first order of 6/7/2022.
That was on main appeal, my lord.
6/7/2022.
At that time, Delhi High Court was not there.
Correct. So your case is that 6/7/2022 is correct. Now you are probably correct also because of the Supreme Court order. Now, if we go into that issue, we are going into the merits of the case, which has again been decided.
See, may not go into the merits of case. The Supreme Court in so many decisions have said that any adverse marks or anything against any judicial member should not be passed. I am only showing this one that, my lord, that this observation is not correct because my conduct was, it says, my lord, the conduct of the members, my lord, any member, any tribunal may pass the order which may be wrong.
Without going into the without only that part I'm worried about, because otherwise we'll be overturning.
So, without going into the merits, my lord, only, my lord, that my lord, the observations which have been made, after all, my lord, everybody has a prospect of the future.
Huh? So without going into the issue at all, basically just this. Otherwise, it can go this way or that way.
I am only to convince your lordship that the remarks which have been made, if I was a culprit, my lord, I have done something, then this is only to convince your lordship, my lord. I don't want to go, your lordship, to the merits. Only, my lord, the observation which have been made, because the order has been set aside, it can always be set aside, my lord. The tribunal's order, the tribunal may commit mistake, the tribunal may illegality may be there. And the Supreme Court decisions, your lordship has already seen, my lord.
So basically the first sentence of the
This paragraph has no necessity, my lord. This says,
yes, but I'm being extra careful because
I will never pray for anything, my lord, which has an effect of, my lord, anything. And your lordship may absolutely make it clear that expunging of these marks will not have any, your lordship is not anything on the merits. And how I can, my lord, on my appeal, the tribunal's members appeal, my lord, the appeal can, my lord, the order can be under subject matter of challenge now, my lord. This is a tribunal member, he's coming for his own sake, my lord. One observation of the High Court, my lord, and the tribunal member, it has a far-reaching consequences. And he has a long career, my lord. Everything will be finished.
can we do? Do we have the power here?
Well, expunging power is always there. A number of cases, my lord, the orders have been passed.
No, this is not a writ petition.
No, this is income tax appeal, the power is there. Well, the income tax appeal, any judgment, my lord, whatever the remarks are there, adverse marks are there, it can always be, my lord. And it's, my lord, this is only to, and if your lordship wants to look into the judgments, I don't want to show them, my lord, about the, that, the remarks, adverse remarks, etc.
I want to see.
My lord, your lordship, Mr. Calculation of your topic. Para 17 and 18, my lord. Your lordship. Itu dia. Lord, another decision, para 27, 28, 29. Itu biasa. You know, the another judgment which I placed before lordship, my lord, that right to reputation has a,
Para.
my lord, the para 1, 12, 15, 21 in the head note.
Okay.
It's if your lordship say it has been recorded.
Yes, yes. Right. Heard Dr. A. Sharaf, learned senior counsel for the applicants.
Applicants.
Also heard Mr.
S. Chetya, Lordship, I am for 2 and 3.
S. Katia, correspondence number 2 and 3. No one appears for the response. No, no one appears for the respondent number 1, as no notice has been issued to the respondent. The applicants are seeking expansion of the adverse remarks and observations given by this court in his judgment and order dated 24/9/24, passed in ITA number 6 of 2024.
Or this is a common, my lord, judgment for 4 appeals.
Passed by ITA number 6 of 2024, comma, Wait, no, not say six, it's a 4/2024, comma, 6 of 2024, comma, 7 of 2024.
And two lordship.
Acha, two of 2024 also, you made two. So, these are four different applications.
Assessment, yes, my lord. 4 different applications have been filed.
Okay. The applicant's counsel submits. No, don't say that. The applicant number one is the judicial member of the income tax appellate tribunal, comma, Kolkata.
Kolkata, my lord.
Kolkata. Whereas the applicant number two is the account member of the income tax appellate tribunal, comma, Kolkata.
And we are also mentioned at the relevant time, my lord. Because now I don't know where they are transferred.
Doesn't matter.
My lord.
Next. The petitioner, the applicant's counsel submits that the revenue had preferred an appeal before the income tax appellate tribunal against the order passed by the Commissioner of Income Tax bracket appeals in respect of various assessment years in relation to the application of section 14A, explanation to section 14A of the Income Tax Act, 1961, which had been inserted by the Finance Act, 2022, which had retrospective effect, which was up. The applicant's counsel submit that the appeals tribunal, wide order dated 6/7/22 allowed the appeals of the revenue was up. After passing of the order dated 6/7/22, the respondent SSC filed misapplications.
No, prior to that, my lord, the another order was passed, no, that order copy I've given. Prior to
Before that, huh?
before.
Full stop. No, don't say that. Subsequent to the order dated 6/7/22 passed by the learned appellate tribunal, the Delhi High Court in Principal Commissioner of Income Tax bracket Central versus ERA Infrastructure bracket India Limited 2024-160 Taxman TAXMANN post.com 92 bracket Delhi held that the amendment made by the Finance Act of 2022 pertaining to the explanation inserted to section 14 capital A by the 14 capital A would be applicable prospectively and could not be presumed to have retrospective effect. Full stop. After the decision of the Delhi High Court which had been made on 16/7/2020. The respondent SSC filed misapplications for rectification of the earlier order dated 6/7/22 passed by the appellate tribunal on the ground that the same was not in consonance with the decision of the Delhi High Court in Principal Commission of Income Tax bracket Central Supra. Further, in another appeal that had been filed before the learned tribunal, subsequent to the decision of the Delhi High Court in Principal Commission of Income Tax bracket Central Supra, the same tribunal had passed a decision in line with the decision of the Delhi High Court.
In the case of some other SSC.
In the case of some other SSC/appeal. However, the learned tribunal rejected the rectification application submitted against the order dated 6/7/22 passed by the learned tribunal earlier. So, sir, next part. The respondent SSC who was aggrieved by the order dated 6/7/22 passed by the appellate tribunal approached this court by way of ITA 2 of 2024, 4 of 2024, 6 of 2024, and 7 of 2024. This court, by judgment and order dated 24/9/2024, disposed of the above appeals, income tax appeals, on the ground that the learned tribunal could not have taken different views in respect of the different appeals, which were covered by the decision of the Delhi High Court.
No, that was not the view taken by Guru.
Okay, what is it?
The court has taken the view on the merit, my lord, that it will be prospective.
Okay. Then sir, what have I said? Different appeals by holding that
At page 106.
the explanation to section 14 capital A.
106, my lord.
Huh?
Page 106.
Where?
Whereat
By holding that the explanation inserted to section 14A by the Finance Act, 2022 would be applicable prospectively. While deciding the said issue, this court made certain observations and remarks in the last paragraph, which has been assailed by the applicant on the ground that the same on the ground that the same caused immense harm to the members of the appellate tribunal. As it cast aspersions on them, which affected their reputation as unbiased as an unbiased authority. That's all? Yes, sir. Next. The learned senior counsel for the applicant submits that though the learned members of the tribunal had taken a decision, had rejected the rectification application submitted by the respondent SSC. Pursuant to the pursuant to various judgments of the pursuant to the pursuant to the judgment of the Supreme Court in another case, comma. He was not going into the merits of the decision passed in the impugned judgment and order pertaining to ITA 2 of 24, 4 of 24, 6 of 24, and 7 of 24. The applicant's grievance was only with regard to the remarks that had been made in the last paragraph of the impugned judgment and order, and not with regard to the merits of the case. The learned senior counsel for the applicant submits that as the passing of disparaging remarks and unwarranted comments on the conduct of the members of the tribunal had caused great damage to the reputation, to their reputation in disposal of appeals for the administration of justice. The said observation slash adverse remark should be expunged. Next. In the case of so will okay, so we just say then accordingly we expunge the last paragraph of the impugned judgment and order dated 24/9/2024, passed in ITA number 2 of 24, 4 of 24, 6 of 24, and 7 of 24. Huh? I'll fill it up later. I'll put
What's
you
in
that.
observe, my lord, in the last, that expunging of the remarks will have no.
Ah. It is made clear once again that the expansion of the remark slash observations made by this court in the last paragraph of the above impugned judgment and order has not made any comment with regard to the merits of the case. We can dispose it of in one common order. Also.
By common order, all the four.
No, common order. And the ayes are accordingly disposed of.
I'm highly obliged, my lord.
All this. We'll have to continue with the judgment later on.
Obliged, sir.
That's it. Yeah, this is also-
On the point of juvenility, your lordship was pleased to fix the matter today, my lord.
Where is that report?
Oh, it's of 16/11/2023, my lord. Injured Manolo?
Sanju Paul, Parimal Paul, Hare Krishna
No,
Paul.
3 persons, your lordship.
Huh.
And as per the report of the inquiry, a finding has arrived at your lordship. According to the inquiry officer, medical board, date of birth of Hare Krishna Paul, his date of birth is 15/10/88.
Just a minute.
Yes. No.
Krishna Paul is
Is 15/10/88. Date of birth. So on the date of occurrence, according to the ossification test, it would be 12 years, 6 months, 9 days. Hare Krishna Paul.
12 years.
Yes, 6 months, 9 days.
The ossification.
Yes.
And when did the incident occur?
Date of occurrence, my lord. Date of occurrence 24/4/2021. 2001.
24 for 21, 2001.
2001.
24 for 2001.
Very good.
There are 3 persons, my
And
lord.
Sanju Paul?
Sanju Paul is my lord. Date of birth as per the report 15/10/83.
So he would be
He would be 17 years, 6 months, 9 days on the date of occurrence.
17 years, 6 months, 9 days.
Yes. And lordship, the other person, Porimal Paul,
Yes.
his date of birth is 15/10/88. Tentative date of birth.
The same. 12 years, 6 months, 9 days also.
Yes. I have
So-
got submissions to make as regards the report of the ossification. I'll be relying on 2 judgment on Honorable Supreme Court, my lord. No, one is Allahabad High Court, another is Supreme Court, my lord.
This was made all on ossification test,
Yes.
not. And when did they finish their school?
No, it was not there.
Did they go to school?
They are not school going men.
Yes.
Lordship, I'll be relying on Allahabad High Court judgment. I have given the copies. Kiran Pal versus State of UP.
Next to Kuntu.
Para 4 minor.
Yes.
Whereupon, with the above facts, it is vehemently contended by Sri Santosh Yadav, learned counsel for the petitioner, that with the declaration of juvenility of the petitioner, he cannot be retained in jail, and this court has to issue audit or habeas corpus for release of the petitioner, declaring his detention in the district jail Agra as illegal. It is contended that even if the petitioner had been found to be guilty of the offence under section 302, read with 149 IPC, his detention had exceeded the maximum period provided in section 15 of the Juvenile Justice Act 2000. And as such, the detention of the petitioner in jail amounts to violation of Article 21 of the Constitution of India. The submission is that the Juvenile Justice Act 2000 is a benevolent legislation, and based on the decision of this court in such matters, the benefit of juvenility is to be accorded to the petitioner. It is contended that with the dismissal of the criminal appeal by this court against the order of conviction, no other forum is available to the petitioner to ventilate his grievance except seeking relief in this extraordinary writ petition of habeas corpus under Article 26. Reliance is placed upon the decisions of this court in Home Secretary Prison versus S. Nilofar Nisha and Amit Singh, decision of Punjab and Haryana High Court on Gurdarshan Singh and State of Punjab and another so and so my lord. Placing reliance on the decisions of Apex Court in Saturday Elias Bhure versus State of Uttar Pradesh, AR 2020 Supreme Court so and so. Arnit Das versus State of Bihar, so reliance has been given. It is vehemently argued by the learned counsel for petitioner. In case of Hariram, AR 2011 SC, so and so, the Apex Court has dealt with the amendment brought out in Act of 33 of 2006, held that with the introduction of Section 7 in 2000 Act, retrospective effect has been given to the provision of juvenile justice, so and so. And the claim of juvenility of the petitioner would be raised before any court at any stage and has been done in the instant case. The Juvenile Justice Board, Bulandshahr, has entertained the application moved by the mother of the petitioner, keeping in mind the above decisions of the Apex Court, and upon inquiry found the petitioner being juvenile on the date of incident. It is vehemently argued that in view of the opposite position of law and the facts of the case, the petitioner is entitled to be released from the jail by issuance of a writ of habeas corpus. Larner's additional advocate general appearing for the state respondent, on the other hand, raised the issue of maintainability of the present petition. It is contended that a writ of habeas corpus can only be issued when the detention of confined person is without the authority of law. That is on the point of loss of juvenility, loss, I'll be relying, my lord. Lordship, may please to give me a minute. Para 27, Lordship, it's a part of, on the point of belated claim. On the point of belated claim. Lordship, para 27, it's a sub-para of para 14. In a recent judgment in the state of Madhya Pradesh versus Anup Singh, 2015 7 SC 773, it is held that the ossification test is not the sole criteria for age determination. Following Bablu Pasi and Anup Singh's case, we hold that ossification test cannot be regarded as conclusive when it comes to ascertaining the age of a person. More so, the appellants herein have certainly crossed the age of 30 years, which is an important factor to be taken into account, as age cannot be determined with precision. In fact, in a medical report of the appellants, it is stated that there is no indication for dental x-rays since both the accused were beyond 25 years of age. At this juncture, we may usefully refer to an article of study of risk ossification for age estimation in pediatric group of Central Rajasthan, which reads as under. There are various criteria for age determination of an individual, of which eruption of teeth and ossification activities of bones are important. Nevertheless, age can usually be assessed more actually in younger age group by dentition and ossification along with epiphyseal fusion. A careful examination of teeth and ossification and wrist joint provide valuable data for age estimation in children. Lordship, in this case, the age of the Lordship, the client of my learned friend. Lordship, above 30 years in case of my lord, Hare Krishna Paul, he was above 30 years and 40 years. As on 62 days were mentioned there. And in case of Porimal Paul, he was 35 years or below 40 years. They could not come to a conclusion. And Sanju Paul, he is above 40 years and below 45 years. Lordship, because the board could not ascertain the exact age. And if your Lordship considers the merit of the case, my lord, without considering this aspect of the matter, two persons are dead, your Lordship, and the eyewitnesses specifically named these persons, my lord. So if your Lordship balances both the thing, my lord, their age as well as since the board could not ascertain the exact age, my lord. They were because of the factor, because it was a belated claim. May I pray the matter may be taken up for hearing, maybe taken up as a final hearing? And paper book is ready, your Lordship.
No, the question is basically, when the question of juvenility was taken up. Now, this court had directed that the test should be done in terms of section 94.
My lord.
Once it has been done, can we close our eyes to it?
No, 94, they did not have any, this one. Yes, in absence of the document, this one inquiry. Yes, medical examination can be done.
Okay.
My submission is that since it was done the ability stage, exact age could not be ascertained because two days were mentioned here, two ages are mentioned here.
Now, this is the problem is now that the report has come,
My lord,
can we act like an ostrich? Bury our head under the ground,
Lordship, because
pretend
age,
that it's not there.
they could not come to a definite conclusion.
No, but then you have just said that they have come 15, 10, 88.
Lordship, they have mentioned two dates if I'm not wrong,
Yes,
my
what are
lord.
the 2 days? What are the 2 days?
In case of Hare Krishna, my lord,
Hare Krishna, Hare Krishna Paul.
Hare Krishna Paul.
You take the other portion also. You take the higher age. What is the higher age?
No, they have come to a finding he would be around 12 years, 6
Well-
months, 9 days.
Then? What-
But no, my submission is I could not make your lordship understand since it was done at the belated stage and his present age, it would be 50, tentative age is 35 to 40 years. And since it was a ossification test was performed, my respectful submission is that they could not come to a definite conclusion whether, because lordship, because
What
he's
is the
35 years to 40 years today. Or the date of,
Maybe.
yes.
maybe?
The exact age could not be.
What does the law say? What does the law say with regard to
One more citation, Vinod Katara judgment, Supreme Court of India.
What
my
does
lord.
it say?
Para 49, your lordship may kindly have a look. Lordship, para 40, para 49.
Yes,
He's not
49.
clear about
very,
it.
very relevant. 49. Correct. Look at 49.
Yeah, I'll be relying on other paragraphs also.
No, you have to read 49.
Lordship,
49.
please to give me a minute,
Read
my lord.
49.
No, 49 may go, Lordship, can we see that?
You read it. We'll have to read, we'll read the portions that are in your favor.
Yes.
Please read the portions that are not in your favor.
I'll read it as a whole, my lord. 49. Ideally, there should not be any dispute as to the age of a person if the birth is registered in accordance with the.
No. It starts with in view of. In view of section 7A of the
She may
2000
kindly-
Act,
kindly
herein
Give me a
referred to
minute, my
above,
lord.
applicable to the writ applicant, the plea of juvenility could be raised in any court, at any stage, even after final disposal of the special
But
leave
that is
petition.
true. That is true.
Then,
I'm not on that. I am on the point that it was done, the bill it is that to a person, the
so
incumbents.
imagine this Supreme Court saying
Yes.
that it can be done even after disposal of SLP. Your own judgment. And to reach the Supreme Court, you know how many years the case needs.
Yes, my lord.
It has to be there for a few years, at least minimum 20 or 10, 15 years minimum.
years only to spend.
Correct. Wherever you go. 17.
Subpara, para 53.
You see, another thing, the judgment that you were reading
My lord.
at this Allahabad High Court,
Yes.
come to para 17. Please read para 17.
My lord. From the above discussion, my lord.
Yes.
From the above discussion, it is evident that the statutory provision in the matter of determination of age of person brought before the board lays down the manner of enquiry which has to be done strictly in accordance with the provision mentioned therein by the court before whom the matter is brought. The credibility or accountability of the documents would depend on the facts and circumstances of each case, and no straitjacket formula can be prescribed as to how and when the court can record its prima facie satisfaction or reject the claim of juvenility at the stage of initiation of enquiry. However, once the enquiry is initiated, the evidence brought before the court have to be appreciated to ascertain the age of a person who claims to be a juvenile. The claim of juvenility lacking in credibility or frivolous claim of juvenility or patently absurd or inertly improper claim of juvenility must be rejected. Lordship, I mean to say, my lord, the prosecution witnesses have, Lordship, they have taken the names of these accused persons, appellant before the court. Whether the act attributed by this accused person can be of a juvenile or be an adult person.
I don't know. You tell me what the law.
Yes, my lord. So lordship has to balance it, my lord.
No, you see,
So
madam.
because the lordship, all the witnesses have taken their name.
Madam, maybe the fact remains that the plea of juvenility can be taken at any stage.
My lord.
Even
That's true.
even after the Supreme Court had dismissed an
My lord,
appeal
my
by
lord.
the appellant.
Yes,
So it can be done at that stage also.
my lord.
And once this court has directed that the ossification of the section 94 should be followed for determining the age, and the report has come, can we now say that we will not look at the evidence which we
My-
had ordered
Yes.
it required to be done? Can we say that?
But my submission is that
It's
the
like you-
act attributed by them cannot be of a juvenile, a person of 12 years of age,
It's
a
not
child
like,
of 12
it's
years
not
of
like
age.
going to a restaurant, you order masala dosa, it comes, you don't want to have, you want to have this thing, some other dish. Not like that. Out here, it's a criminal case.
Yes, lordship, but your lordship, can it be an act of a 12 years of person? When the IBTs is revealed your name.
I agree with you, but then I have got to follow the law. I cannot go by what what is my
But
perception.
Supreme Court time and again has said, Lordship, ossification takes, Lordship, the report arrived with or whatever is the result finding.
Madam, is there a margin of error in an ossification test?
Plus minus 2 years.
1 or 2 years. I didn't say that. You told me. If there's a margin of error, and where did you get that plus minus 2?
There are judgments.
There are judgments, and who made those judgments?
The Honorable Supreme Court as well as your
Then
Lordship.
aren't you and I bound by that?
Judgments.
What remains? That's all. You see, our individual perceptions might have some basis, but we are bound by the decisions made by the Supreme Court and the law. Sometimes even we might feel that this could be wrong, but then we are bound by the law.
Correct.
That's all. The long and short of it is that only. Even when you consider 12-year-old killing a person, doesn't seem plausible at all. But what to do? The law provides that ossification test can be done at any time. And once it is done, the report has come. Probably that report was fabricated or what, that's a different issue. That has not been taken up by anyone.
Conducted the inquiry, madam.
Huh?
District just conducted the.
Maybe, but we do not know.
No scope of.
There's many a slip between the cup and the lip.
Yes.
So we don't know. That portion too, we don't know. So we are only going by the report. And the report is not put to challenge by anybody. So what remains? What hearing can be held besides that? How long have you been in jail?
10 years, my lord.
2 persons died.
Madam, maybe 200 persons died also. How to do?
But there will be 4-6 accused still appeal is to be heard, my lord.
What?
For another 4-6 persons, appeal is to be heard also.
For another
Only
4
3-year juvenile as per the direction.
One was already left earlier. Shivupal has already
Shivupal.
by
So
Honorable
this case, this appeal is for these 3 juveniles.
Yeah, no, there are 3 distinguished appeal. I mean, one, my lord.
No, 94 is for whom? Let us see. 94.
Yeah,
Who are
your
the-
lordship will call the name and
3%.
response. No, card key to appeal.
Shivupal has been declared juvenile
Yeah,
long ago, 94.
1994, my lord, I am appearing for Porimol, my lord.
Yes.
Porimol. Porimol is.
And Shivopal was one who was already released by the Honorable High Court.
Because of
94
because of
time.
juvenility.
How many appeals are here?
In total, my lord, it will be 6 or 7.
No, appeal petition 1.
Yeah, my lord, I'll give one by one if your lordship will take it from the beginning. Criminal appeal number 50, my lord.
50 of 2020,
Yes.
2016.
2016, then
No,
Nirmal
that-
Paul and another one.
That will take the name, my lord. I'll just give it one minute. There is a Hare Krishna Paul, that is the appeal preferred by Hare Krishna Paul in appeal number 78.
2016.
Yes. Then the other appeal, if your lordship will come, my lord.
94. to
94.
Yes. Sibopal already.
Shivapal is already declared as a juvenile earlier, my lord.
Yes.
Now we are dealing with accused appellant number 3, Porimol Paul. Porimol Paul is before your lordship as a juvenile.
94.
94.
No, 94 CB.
No, tinta আছে.
Okay, so
Shivapal-
this Shiva Paul is what? He's
No, that
Already declared as
is
juvenile.
registered as Shivapal, first name.
Shiva Paul.
If we
also
come
is
to
there.
page 286,
What about Pratap Paul?
He is 84 years old, father.
Mother cannot be mother.
No,
Father.
father.
Mother.
84 years old.
Pratap Paul, 84. This is what this
Yes, ma'am.
dispute or something. What is this?
Property.
then another appeal 50, my lord.
Yes.
50, there are 2, my lord, Nirmal Paul and Sonju Paul. এইটো কাৰ হয়? তোমাৰ হয়?
Nirmal Paul
Juvenile.
is Sanju Paul.
Juvenile কোন হয়?
Sanju Paul. Sanju Paul.
Sanju Paul is a juvenile now. So, no, you have given me only 3 appeals. There is a, you said there were 4. 50, 78, 94. Is
Yes,
there any
ma'am.
other? That's all.
No, there is another 50, my lord, of 2017.
Oh.
There is 250, my
Paul.
lord. One is for 16 and one is in the year 2017.
Who is
He is appearing as an amicus curiae.
17? Who is there?
Directly.
Vipul Paul, my lord. There is criminal appeal 50 of 17.
Only one person.
Only one person. He's on bail, man.
And who, what about 78 of 2016? Who is there?
Hare Krishna.
Hare Krishna.
He's
Only one person.
tested, yes.
Okay.
Decide করা।
Order দিবে না? তোমার appeal কি করবেন?
Okay. So what do? We can dispose of this
Yes.
entire thing. When? After lunch?
After lunch.
What is that 45? Oh, it is Anshuman Bora's thing. Oh, Miss A. Begum.
It become,
You're ready, no? Item 4 and 5.
after her item, it may be taken up, my lord.
Yes. Ah,
Much of it.
yes, madam.
Lordship. Lordship. My learned friend have given the eyewitnesses of 8, 9, 11, 12, and 15.
Huh? Yeah.
PW 8,
No. Appellant 4, 6, 7, 9, and 10.
no,
Yes,
Lordship,
yes.
they are his appellant and eyewitnesses he have
8,
referred.
9, 11.
8, 9, 11, 12, and 15.
Prosecution witness, eyewitness.
Lordship. They
That-
have
There is one more, 5, but he
5.
has not implicated anyone, my lord.
5, PW 5.
5, but he has not implicated out 10 also, out of these all 10 also.
No.
Nobody.
Lordship. Lordship, the PW 8 Lordship, he have specifically mentioned about accused number 3 Abbas. His
Accused
name-
number 3.
Accused number, appellant number 3.
Appellant number 3, he is not.
No, Lordship. I'm saying as a whole, Lordship. Only then, Lordship, this accused person, Lordship, have not mentioned those names. My learned friend have said, but only that PW 3 Lordship, he have said about Hazrat Ali. He was present in his
Let us see where.
page number 44, Lordship.
He has, my lord. He has not assaulted deceased, my lord.
Yeah, but no, I am not on that,
Page
Lordship.
44.
Page 44,
40.
Lordship.
Last line.
Last line, that Lordship, may I read, Lordship?
Yeah.
On the, I saw accused from Lordship, I came up.
Page 44 of what? The
44.
IA?
Aye.
Oh, IA. Page 44.
Last from upper portion, Lordship, 5th line.
Yeah.
I came out of the house and rushed to the road and saw that a fight had started between the accused persons and my brothers Sabed Ali and cousins on the road near my house. I saw accused Sham, Yasin, and Asmat assaulting my brother Sabed. Before I could reach near my brother, while running towards him, accused Hazrat. Hazrat had dealt a blow to my wrist by means of a lathi, accused Hatem, so and so on my head. He have injured this PW3 and he was present at the moment of the altercation with his brother, Lordship.
Correct. But where is the hit on the
No,
deceased?
no, I'm just saying that his name is there within the accused that he was also there in the altercation. And
So there was a fight.
there was a fight. And mainly those accused are lordship, my learned friends, petitioners are not named, specifically not. Especially only 6 already died, lordship, main accused person all
He
died,
already died.
already died.
The
Main
appellant, no?
appellant.
Number 6 died.
Not appellant manner during trial.
During trial, lordship.
6 accused died.
6 accused have died.
6 accused died,
Altogether, how many accused?
26, 2 absconder.
Oh my God. 26 accused, 6 have
Lordship.
died, 2 have convicted, so 18 left.
82 were juvenile.
2 were juvenile, so 16 left.
Three,
Then 15 left.
15. And among this 15,
I am representing 10, my lord.
2 are absconded during the trial.
13 left.
13 left.
13 left.
10 are dead and 3 my other learned friend.
Anyway, we'll come to that. Let us finish his case.
Madam.
Heard Mr. A. Bora, learned senior counsel, for the applicants, number 1 to 10, who are amongst the 13 accused persons who have been convicted by the court of the additional Sessions Judge Vilasi Para Dubri, Assam, in Sessions Case number 108/2001, under Section 302/325/323/149 IP. While judgment dated 5/10/24 and sentence order dated 7/10/2020. Next part. The learned counsel for the applicant submit that the applicants have been in jail since
Last 8 months, my lord, date of judgment, my lord. 7/5/10/24, my lord.
since the impugned judgment dated 5/10/24. He submits that he is praying for suspension of sentence in respect of the applicants number 4, 6, 7, 9, and 10 only. Correct. He submits that as the eyewitnesses to the incident, that is PW 5 also. 5, 8, 9, 11, 12, and 15 have not identified the applicants number 4, 6, 7, 9, and 10 as the persons who had assaulted the deceased, the applicants number 4, 6, 7, 9, and 10 should be released on bail after suspending the sentence inflicted upon them in pursuance to the impugned judgment dated 5/10/2020. Full stop. Next para. Ms. A. Begum, the learned additional PP, admits that the prosecution witnesses have not made a mention of the applicant numbers 4, 6, 7, 9, and 10 as the persons who had assaulted the deceased during their evidence. Yes, you are there? No.
But in item number 4, I am not there. In item number 5, I am.
Okay, in this one you are not here. Okay, right. Right, we have heard the counsel for the part. This is an application under section 389 of 430.
389. Not 430.
430 BNSS for suspending the sentence inflicted upon the applicant pursuant to the impugned judgment dated. Says so, huh? on considering the fact that the applicants 4, 6, 7, 9, and 10 have not been identified by the eyewitnesses as the persons who had assaulted the deceased, we are of the view that the applicants should be released on bail. So accordingly, the applicants number 4, 6, 7, 9, and 10 are released on a bail bond of rupees 50,000 each, with one surety of like amount to the satisfaction of the learned.
Additional session judge Bilasipara Dhubri, my lord.
Consequently, the impugned sentence order dated 7/10/2024 in Sessions case number 108/2001, insofar as it relates to the applicants number 4, 6, 7, 9, 10 is hereby suspended.
Publish.
I is accordingly disposed of. Then, now the next one.
Lordship may reflect the names also, my lord. Otherwise, names also. Applicant.
Okay, just a minute, The 4, 6. Just reflect their name. Look at the applicant. Just give the name. Just there.
Okay.
What are the name? Just mention.
For Khaibar Ali,
4 Khaibar Ali.
alias Khaibar Ali, Shohid Ali,
Sabit Ali is which applicant? Stick.
SO HID Shohid Ali, alias Sahidur Rahman.
Acha, this here.
7 Hazrat Ali,
But
Publish.
yeah,
My lord.
your case is what? You have been mentioned.
Mentioned, my lord, yes, mentioned. So only thing, my lord, here, my lord, 3 persons unfortunately died, my lord. So far,
How many persons died? 3.
Three, my lord.
Okay, so okay.
So, my lord, that regarding one,
On
my
the
lord,
deceased persons, it will be,
yes, yes, my lord. So regarding subed, my lord, one subed, there is no allegation against others, my lord.
Against?
Those persons already died, my lord. Regarding one deceased.
We are with regard to your application.
Yes, yes, sir. No, what I meant, my lord, because there are 3 deceased, that's why, my lord. 3 deceased, that's why. Regarding one deceased, already the persons who were involved, they are died, my lord. Now, there are now 2 deceased, my lord, the Moinul. One is Moinul, my lord, and one is Asaruddin, my lord. So regarding Moinul, my lord, PW 12 and 15 stated that Siddiq, my lord, one of the appellant here, my lord, Siddiq assaulted with a spear in his eyes, my lord, eye. So there are 3 appellants before lordship now, my lord. So regarding Siddiq, my lord, Abu Siddiq, there is 2 witnesses, 12 and 15, they have stated in the eye, my lord, the spear.
Eye of the deceased.
Yes, my lord. And there is PW 9 also stated that Siddiq and Inas. Inas is also before lordship, my lord. But specific 12 and 15, they have stated Siddiq hit Mainul by a fala in the eye, my lord. So 12 and 15, my lord, regarding my lord Siddiq, it is remains, my lord. And regarding the other, my lord, Asuruddin, my lord, it states that, my lord, the name of Ali Hussain, my lord, he is the appellant number 1, my lord. Ali Hussain, PWH stated that with a lathi, my lord. Ali Hussain assaulted Asuruddin with a lathi.
Assaulted the deceased.
Yes, with a lathi, my lord. And PW 9 did not state any weapon, my lord. And PW 50 stated stick, my lord. This is the evidence which goes against me, my lord, to be fair enough. Now, my lord, here, although lordship, my lord, regarding that those 5, my lord, it was not praised, my lord, early application. Here, my lord, there are 2 sets of evidence, my lord. There, here, my lord, one, my lord,
one stated in favor of the defense, my lord. The PW1, my lord, he narrated the story in the manner what we had stated in the cross-examination. That because he stated that, my lord, the other side were the aggressor, my lord.
Well, I don't know. That is always that is always how you look at it.
But it is, my lord,
Mm.
my lord,
It
if you
depends.
go through it, it is there, my lord. What I have said, it is there. He has stated that PW1, he has supported the defense story that, in fact, the informant side, they were waiting there. And when this accused appellant side went there, my lord, they were assaulted. It is
So only one side died.
one side.
Both
yes.
sides didn't die.
Well, because it states not a 50%, somebody says 100 people were there. And free fight, my lord. Two groups.
No, probably not a fair fight.
Maybe.
Because only one side died.
Imbalance. So my respectful prayer, my lord, that there is two sets of evidence because PW1, he supports the defense case. And he states that it is a mutual marpit, my lord. Thereafter, my lord, PW2 also, he saw the fight happening, my lord. And he also said that it was between two groups, my lord. Our side, his side, and the group of the accused person side. And he has not named anyone, my lord. So far, these appellants are
No,
concerned.
but then there were eyewitnesses who saw all your clients. A1, 2, 3.
Because kind of 1, 2, 3, and 5, in fact, my lord, 5 is the informant, my lord. He also does not say any, my lord, no role has been attributed, my lord. So far, the informant, my lord. And other than that, my lord, 6 and 7 also, they said there is land dispute because of this happened, my lord. And my lord, now PW8, my lord, that who stated our name, my lord, he stated that there was PW4, 6, 7, and 9 also, my lord. As you rightly, Lordship pointed out that he might not have known the names, my lord. So PWC8 also, my lord, his presence, my lord, doubtful because 4, 6, 7, and 9 doesn't say about him. And so far, PW9 is concerned, my lord. And one.
So this number 3, Siddiqui is the one with the spear in the eye.
Yes, my lord.
That is, forget it, no chance.
Yes, no chance, my lord. And here,
Then this Ines Ali.
Yunus Ali, one reference is there, my lord. Regarding Asaruddin, my lord, he was alive, my lord. Kindly have a look at 154, kindly once, my lord. Page number 154, my lord.
Aye.
Yes, my lord, in an additional affidavit of, that is, my lord, IA 1228, my lord, 2024, my lord. Page 154, my lord.
Yeah.
There, my lord, Lordship, kindly see, my lord, that from down, my lord, around 10th, my lord, that this is Moinul died the next day. Asaruddin died after 3-4 days. I talked to Asaruddin, but I have not talked with others. Asaruddin did not name anybody of the accused, my lord. Asaruddin, fortunately, he was there for 2-3, as per that, my lord. 3-4 days he was there, my lord, and he did not state anybody's name, my lord. And
what is the role attributed to the applicant number 2?
to my lord. I'm coming, my lord.
We were asking you that.
Ines, yes, my lord.
Yes.
Ines, my lord, I have stated, my lord. Ines, Moinul, regarding Moinul, my lord, PW9 stated that Siddiq and Ines assaulted. PW9, my lord.
Weapon not mentioned.
And yes, but PW12 and 15 stated that Siddiq was the person.
And one
Yes.
is Lathi.
Yes,
Yes.
yes.
In
La-
us, lordship, with Lathi.
Lathi Lordship, fine, my lord.
That
PW8,
is
my lord.
PW15 had said lordship.
PW8, that is regarding Asaruddin, my lord. It starts from 142, my lord. PW8, my lord. (143) lawsuit find, my lord. Accused Ali Hussain and Naushad gave blows on Asaruddin by Lathi on the head.
Who is this Yasin?
Yasin, my lord, different.
Yasin is not before lordship.
And PW 9, my lord.
At the time, accused Abbas Ali Yunus
Yasin.
and Insab Ali.
Absconded lordship, Yasin, during trial. Page number 175 lordship, PW 15. One 175.
Last but 10th line, my lord. Asaruddin with stick, my lord. Ali Hussein, Noshad Mollam, Ali Hussein, Sadiq Ali attack and beaten Asaruddin with stick, my lord.
Abu Siddiq attack Moinal with a fala.
And in fact, my lord, that witness, my lord, PW 15, my lord.
Where is the involvement of this Ali Hussein?
Ali
Acha,
Hussein,
he beat Azaruddin with a stick.
yes, my Ali Hussein, Lordship find first PW 8, my lord.
And Ines Ali?
Inas, my lord, what I have find, my
Huh?
lord,
One,
PW 9, my lord.
one for the. Ah.
In fact, my lord, here on the PW 15, one line I'll just try to show, my lord, that page 177, my lord. He was in the other side of the bank, my lord. So his presence, my lord, little doubtful, my lord. 177, my lord. I'm just reading the line, my lord. I was present on the other side, west side of the river bank. And he states that at the time of incident, only 3%, namely Moinul, Asaruddin, Sabed, went to the place of occurrence. Those three who died, my lord. If possible, my lord, that Siddiq, my lord, there is specific others, it can be considered, my lord. There are 22.
Yes, madam.
Also, there is a specific allegation against Siddiq Latu. He is with a fala. And lordship.
Pala means what?
Spare.
Possibly
Spare lordship.
And there is specific allegation against the other two also.
Lordship.
Is there? Abbas and Inas. Inas attacked Moinul. Moinul also died.
Moinul died, my lord.
3% like it.
Accused Ali Hussein
Yes, my lord.
gave blows on Asaruddin by lathi on the head.
Yes.
He also died. Right. Heard Mr.
A Chaudhary.
A. Chaudhary, learned counsel for the applicants. Also heard Ms. A become additional PP. Acha, what about you? You have got anything to say?
Here in three appellants lordship in this case lordship. Ali Hussain was implicated by four prosecution witnesses. And
Just appellant number 1,
Ali Hussain
Ali Hussain, he was
implicated by four eyewitnesses lordship. And he is found involved in assaulting lordship. This is Asruddin and Moinul Haq. And Yunus Ali lordship. So far the Yunus Ali is concerned, he was implicated by lordship 5 eyewitnesses. He was also found in assaulting lordship Moinul and Asruddin. And Abu Siddiq lordship, he especially attacked the lordship, the deceased Moinul Haq lordship. So all the witnesses, eyewitnesses implicated the three appellant here lordship. And this is the main person's lordship. So at this is there.
okay. Heard Mr.
80 short for the informant.
A. Sarkar, learned counsel for the
Informed.
informed. This is an application. And section 430 bracket 3 BNSS for suspension of the sentence inflicted upon the appellant by sentence order dated 7/10/2024, on the basis of the impugned judgment dated 5/10/2024, passed by the learned additional sessions judge Bilasi Para, Dubri, in sessions case number 108/2001, by which the appellant numbers 1 to 3 have been convicted under section 302/149, 302/325/323/149 IP. The learned counsel for the applicants submits that there had been a group fight among two groups of persons, and the conviction of the appellant by the learned trial court was and had been done by not taking into account the fact that the applicants were also being attacked by the other group. It submits that though they are eyewitnesses who name the applicants as the perpetrators of the assault on the three deceased persons, the evidence shows that the death of the deceased persons could not have been due to the actions of the applicants. Next paragraph. No, continue. They accordingly submit that the sentence inflicted upon the applicant should be set aside and should be suspended. And the applicant should be released on bail. Full stop. On the other hand, the counsel for the respondent submit that the applicants have all been implicated by eyewitnesses as having assaulted 2 out of the 3 deceased persons. Correct? All
Right.
three. All three. All 3 deceased persons. In this regard, they have relied upon the evidence of PW 8. Only 8. No. 5, 8, 9,
9, 11,
11,
12 and 15.
12 and 15. Good stuff. They submit that the evidence of the eyewitnesses shows that weapons had been used by the applicants for causing injury on the deceased person. They submit that as 3 persons had died due to the assault by the group in which the applicants were a part of, the application should not be allowed. We have considered the submissions made by the councils, and on perusing the evidence of the eyewitnesses, we are of the view that the the sentence imposed upon the applicant should not be interfered with at this stage. Consequently, the application is rejected.
Much obliged, ma'am. Obliged.
Then in the main case, you write in both. A paper book has to be made or not?
Paper book made.
Right. As the TCR has arrived, a registry to prepare the paper book and list the matter after 4 weeks.
Much obliged.
Public. What? Oh, really?
Other side is not there.
Okay, so this May I please your lordship, my senior Mr. Z Kamar is in lags here. Let me inform.
So what to do?
I leave it to your lordships.
Without there being a council, we cannot proceed. But there are evidences against the other appellants. Only with regard to these 3.
Even allegations are against them also.
No, but then the age,
Yes, because of the age.
that age. Because of their age, the only thing that can be given to them, even if they are convicted, is 3 years. Beyond that, they cannot. Okay, right. Submission has, it has been stated that the senior counsel for the appellant, Mr. Z. Kama, is on legs in another court. Ms. B. Buyan, additional PP, appears for the state. Right. How many convicts are there in this? How many were convicted out of how many accused?
7, okay? 7. Sorry, what to बनाए सभी लोग?
How many accused were convicted?
Lordship. Seven plus. Eight convicts.
8 convicts.
Yes, page 232. Heard all the 8 convicts on point of quantum of fine to be imposed upon each of their respective so and so.
8 convicts are there.
8, how many accused persons?
So total 9 persons
Nine.
face trial.
9 face trial.
Trial.
One was acquitted.
Yes, madam.
Are you sure?
No.
Don't say yes.
Total 9, my lord, as per the judgment, my lord.
9 accused or 9 convicts?
9 accused, my lord. They face trial.
If 9 accused, how many convicted? You don't know.
8 were convicted, my lord.
9 accused, 8 convicted.
8 convicted, my lord.
How many dead bodies?
2, my lord.
6,
Two.
7, 8.
Group fight.
This is
That
championship.
the group actually is not a group fight, my lord. There was some between the market, inside the market, it took place, my lord, between the brothers, my lord.
2 brothers.
So, yes,
And both died.
brother died.
Huh?
Both dies.
Then who is if both died, then what? Each of them had their own.
My lord, is the complainant party, their brothers died, my lord, and the shopkeepers, my lord, they are shopkeepers actually. This is fish market.
So there were 2 groups fighting.
Yes.
Right.
Mr. Biswas is there, man. Because I'm not a place of juvenility, my lord. I was in. My appeal is different, my lord, because I was allowed to go on bail, my lord.
No. Whether you're on bail or not, that's not the issue.
The juvenility part.
Juvenility part,
Yes, my lord.
we have to go by the report.
Yes,
There's no doubt about that.
yes, my lord.
So that is a different issue. Now, with regard to the other appellants, the
Yes.
other convicted persons,
Yes, ma'am.
what about them?
On merit, we have to argue then.
Actually, that's what we're here for.
Oh, yes, yes.
We're not on the other person.
No. Because we of the prison, my lord, on the point of juvenility, you're not.
Juvenility, we have decided. Basically, our mind is made up
Yeah.
that once we have called for a report has been made as per Section 94 of the 2015 Act,
Yes, ma'am.
has to follow.
Yes.
Now, once they are juvenile,
They declare juvenile.
when they declare juvenile, then if they are convicted, 3 years they have to be in prison. Beyond that, they cannot.
8 persons
Not in prison,
convicted
but of course in
died.
remand home, my lord.
Huh?
Not
Correct.
Ah.
Whatever.
in but the things that
But
now-
if they have already undergone 3 years, then end
Yes.
of the matter.
So nothing remains, my.
But you're for who? You're for those 3 only.
Oh, I'm only for one. He is for one.
No, you're for one of the juveniles.
Juvenile, my.
Then your matter is finished.
Yeah.
Huh?
No. Criminal appeal is there, my lord.
Oh, you're for that's what. In the criminal appeal,
Yes.
you're for 3 appellants, no?
Yes.
And out of the 3, one is a juvenile. Or 2.
One is already declared juvenile. One is in the process.
One is in the
And
process.
one is a person who is of geriatric age, my lord, 80.
Okay, so that has to be
84.
considered.
Juvenility as a tinjon manu. Tinjon
My
reports
appeal,
have
my
come.
appeal.
Oh, but it will appeal different. Hare Krishna.
So this has to be decided in one judgment.
Yes.
Entire thing.
Yes.
4 appeals in one judgment.
Yes, that is on merit.
Naturally.
Absolutely.
Now those persons who are juveniles going to be declared or who have been declared juvenile, whether they have undergone 3 years,
More than 3 years.
more than 3 years.
10 years. As on today.
So that is the end of the matter now. For
Yes.
them. So yeah, for you it's only that 80-year-old person.
Yes.
That's all.
Yeah, oh, bhai. 80 and 84, what difference does it make?
84 and a half.
Yes, okay, to be satisfied. So we'll have to argue for that matter.
So yeah, we are ready. It depends upon you all.
So far I am concerned, I'm not ready, he is ready. Arambo kore appeal.
Yeah.
Yes,
please, my lord.
Any other day?
আজকে আমরা গেলে আজকে জুভেনিল কোর্টে ডিসাইড করো
Or details?
My lord,
My other counsels wish to declare the juvenility today itself. And there are something difficulties to hear the matter final here.
Why?
And for final here.
You see, we are not very keen on hearing, but it is our duty to do it. So that's why we are going to do it.
Lordship, counsel, all the counsels are not ready. Only my learned friend is ready. to
I am ready,
argue
ma'am.
today.
He's ready.
Mr. Kamar is not ready.
I have got two appeal, ma'am.
Not ready.
So,
76 and 50 appeal number 50.
so you are ready or not?
Yes, I think ready if your lordship is pleased to hear,
Uh,
and I can.
We are not very pleased to hear, but we have no choice. It's that's what we are paid to do.
Yes, absolutely correct.
Only problem is we don't like to do it in part
Piecemeal, yes.
because we do not know when. Because supposing we hear you today, when they will be ready, we do not know. That is the only problem. If you are going to finish today, there's not a problem.
So that may kindly be fixed. They have been my accused person, Sri Hare Krishna.
নাম তো কি আপনার কি?
Okay, right.
Client-ৰ নামটো কি?
More client নাম হবে এটা হল কি নির্মল পাল, এটা হরে কৃষ্ণ পাল, আৰু এটা
Where is the order directing that the juvenility test should be done?
Well, that is ordered, it is up.
Okay, this order
29, 2023.
Okay, right. That's right, huh?
All right.
Criminal Appeal 50 of 2016, Criminal Appeal 78 of 2016, Criminal Appeal 94 of 2016, and Criminal Appeal 50 of 2017 have been made challenging the conviction of 18 accused persons.
Not 18, I believe, man.
Days to 33.
Eight accused persons.
Yes.
Two died, your lordship, eight confirmed.
White judgment dated 19/1/2016, passed by the additional sessions judge number 2, Kamrup Metro at Guwahati, in sessions case number 437(K) of 2011, under section 302/34 IPC. The issue has arisen. No, the question of next 2 persons had been killed.
One guy.
And
233 cancer. Persons with a two.
no, 2 persons had been killed.
233 such that.
On which date? On 24/4/2001. Due to which, how many accused were arrested?
9 minor.
9 accused persons were arrested.
Trial.
Then what happened? 1 was acquitted.
Two died, my lord.
Then how can it be 8? How can 8 be
10,
convicted?
so I was making the submission.
10 were arrested.
Anukul Paul.
10 accused persons were arrested, huh? 2 died during the trial proceeding, and the learned trial court convicted the remaining 8 accused persons under section 302/34 IPC. Next para. Three out of the 8 accused persons, out of the 8 convicted persons, filed criminal appeal 94 of 2016. And they are number one. No, and they are two persons, no? Shri Nirmal Paul and Shri Sanju Paul. Correct. Then
One lady accused was acquitted, my lord.
no,
Swati.
no, I'm just finding out who had filed the case.
IA is filed. IA is filed by 3 of them.
No, I'm talking about the appeals. Then in this 78,
Swati.
you're right. Criminal appeal 78 of 2016 was filed by the convicts.
78.
No, it was filed by Shri Hare Krishna Paul. Okay. By the convicts, one to. Then 94.
My lord, my appeal number is 78.
78.
Yes, my lord.
Correct. So I've written 978. How does it matter?
He told me that 76 is not the correct.
78.
He's got a hearing problem. Okay, right. Criminal appeal 94 of 2016 was filed by Shri Siba Paul, alias Sibu Paul, Shri Pratap Paul, and Shri Parimal Paul. Full stop. Criminal appeal 50 of 2017 was filed by
Nirmal.
huh?
Even Nirmal Paul. Nirmal Paul.
Which one, my lord?
50.
Was filed by Shri Bipul Paul.
It's by name.
Huh? Full stop.
Oh, there are
Next
two
one.
50s, my love. 150 of this.
Yes,
16?
yes. Next paragraph. On a plea of juvenility, having been taken by Shri Hare Krishna Paul. How many took that plea of juvenility?
Three, my
Having been taken by Hare Krishna Paul, Sanju Paul, and Parimal Paul, this court, while order dated 29/8/23, directed that an inquiry was to be made by the Court of the Additional Sessions Judge number 2, Kamrup Metro, Guwahati, with regards to the age of Hare Krishna Paul, Sanju Paul, and Parimal. Pustak. Where is that report?
report is dated 16/11.
In which case? In which case?
For no copy has been given to us.
Next para. Pursuant to the order dated 29/8/2023 passed by the Additional District Session Judge number 2, Kamrup Metro Court, has submitted an inquiry report dated 16/11/2023 regarding the age determination test carried out on the above three persons in terms of section 24 of the Juvenile Justice Care and Protection of Children Act 2015. The Court of the Additional District Session Judge I'm good. I showed that. An authentication test and next week was done on the three appellants. Pustaka. The report of the report, no, the age and the age determination test done on the above 3% by way of an ossification test brought out the following results. The Hare Krishna Paul was found to be approximately 12 years, 6 months, 9 days on the date of occurrence of the crime, that is 24/4/2001. On the other hand, Sanju Paul was found to be approximately 17 years, 6 months, 9 days. While Parimal Paul was approximately 12 years, 6 months, 9 days. Next, though the learned APP has additional PP has stated that the age determination test should not be considered as a prayer for the same had been made after many years, the Supreme Court in the case of Abuzar Hussain versus State of West Bengal. No, wait, no. Vinod Katara versus State of Uttar Pradesh has held 2023 15 SCC 210 has held that the plea of juvenility could be raised in any court, at any stage, even after disposal of the special leave petition under Article 136 of the Constitution. As the present issue of age determination of the three appellants has been made during the pendency of the present appeal before this court, which had been done on the orders of this court. It would not be proper for this court to ignore the results of the ossification test. And naturally, no reason,
But
we
I
have
made the submission contrary because it was done after a period of 30-35 years. So ossification test, the result arrived with, but in the ossification test, Lordship,
okay. First up, though the ground for though the learned additional PP has stated that the ossification test, which had been done after 35 years, should not be considered. We are bound by the decision of the Supreme Court in various judgments, including Vinod Katara versus State of Uttar Pradesh. Supra. As such, we cannot turn a Nelson's eye to a test report made in terms of Section 94 of the JJ Act 2015. Which had in turn been made on the basis of an order passed by this. Next. A perusal of the ossification test report shows that the appellants Hare Krishna Paul Hare Krishna is in which case? In whose case? Your case? Hare Krishna.
Yes.
Which case? 78.
78 of 16.
Bracket, right? Criminal appeal 78 of 2016.
Yes,
16.
60, comma. Sanju Paul, in whose case?
yes, I am. also.
Again, 78.
78 and 50 appeal number. Sanjupal also 50.
Sanju for 50 or 16?
Single cost.
50 of 16 or 50 of 17? Bracket, criminal appeal 50 of 2016.
50 of
And
16
Parimal Paul, criminal appeal number
50.
94 of 2016.
2006.
Enough. Just a minute. Yes, what have I said? What?
94 of 6, correct?
Were below 18 years on the date of the offense. As the appearance Hare Krishna Paul, Sanju Paul and Parimal Paul have apparently been in judicial custody for more than 10 years, as on the comma. The said juveniles would have to be released from judicial custody, even if they are found to be guilty of the crime in the present appeal.
Krishna Pal already been released earlier on bail. And Sanjupal also already been released on bail. Man.
So what do you want now? So what do you want?
If they are juvenile, my lord, then they are to be discharged from the case.
Correct. Just a minute. So let me finish my order at least.
You are protecting, no? I'm excited, properly.
You see, the thing is that whether we find them guilty or not guilty doesn't make a difference.
Yes.
Even if they are guilty, since they have already served more than 3 years, nothing remains. Everything is gone now. So what have I said? Consequently, the above three appellants having been found to be juvenile in terms of section 94 of the JJ Act 2015. Now, the appellants are accordingly discharged, not discharged. They can be convicted of the crime. They can be. There is a. I think there is this. There is the judgment. I think this is Vikram Nath's judgment is there. They can be convicted. Only they are released. They are accordingly directed to be released from judicial custody if not released. In the event they are found to be in the event they are on bail, the bail the bail order, they are discharged from the regards of the bail order issued against. That's all.
Yes. Good
And
enough.
as the counsel for the parties are not ready for final hearing today with regard to the other appellant, list the matter for hearing when?
Full purpose is also common order.
26 of this month.
23.
23, man.
Holiday, last, will be last working day. 26,
23
23
September.
23
motion days.
September.
Tuesday.
Officer ko বন্ধ,
করলো মই night.
বন্ধ নেই?
পূজার বন্ধ।
26. After puja vacation, my lord.
হয় আপনার পূজা বিফোর করো।
Okay, but 23 কেটে?
Yeah, then you come do
Date
earlier.
আছে না? Date আছে না?
This month, 15, 16 better করো।
My lord, of this month, if as per convenience of this honorable court,
When do you want?
কোক ডেটাটা কোক দাদা।
15,
15, 16 of this month.
15, 16 of this month.
Yes. Possible, if possible by the court or
When do you want? When do you all want?
15 or 16.
Okay, list the matter on 16th.
16.
Develop.
Hello. Master.
Is that? I don't know. We get in the main case. Huh? In the IA, in the IA. In which IA is it? That was in the main appeal. You put in the main appeal. It's okay, put in the main appeal. Any other. Let me see the IAs. IA, is there any IA can be disposed of? Give me this item 10. In item 10, there's an IA. IA 313, letter 31. Pratap Paul. Oh, this for the old man.
In an application.
For the old man. Parimal Paul, Pratap Paul. Pratap Paul, 81. Is he, was he identified by the witnesses?
Oh,
Top
one
court.
court is there, my lord. She had prepared a charge in it.
Pratap Paul, was he identified?
Say.
Parimal Subud. Name Parimal Subud. লেখা নেই এই তো প্রেসিসটা করেছিল প্রতাপ
Protap.
সেটা কি
All are within their same locality, that's why.
Huh?
All are within their own locality, my lord, both accused and informant party. So identification normally should be there. my lord.
In the hand of Pratapal, there was spear, your lordship.
So the death was due to what?
Was spear injury, my lord.
And he was holding the spear.
Yeah, that is.
No, there are like 2 persons died, my lord. 2 postmortem report is there.
So the old man was with the spear.
Yes.
One was hit by a weight stone, my lord.
Yes.
5 kilo weight.
And weapons were recovered.
How many people were holding spears?
One, I believe.
Only he. Then. Otherwise, 86 years.
Pratap Paul, lordship was talking, saying about Pratap Paul. Accused Pratap Paul assaulted a deceased Subud with stick on different parts of his body, including nose.
Stick, not
Yeah.
spear.
No, in one place, one witnesses said he was beaten by spear.
Because
He was
there are
holding a spear.
many contradictions, my lord, regarding the manner of assault.
The two versions are there, my lord.
2 versions. Then is a
Because the shopkeepers were there, my lord. One lady was there.
She is the alleged eyewitness. নিজামে জানে
That too evidence of it.
Rita Gwala.
Rita Goala eyewitness.
she is the main star witness of it. PW1. PW2 is basically the star witness of the case, one lady, my lord, Rita Gwala.
There are 3 eyewitnesses. One is injured. 2 have been declared hostile.
Eyewitness.
Yes.
What are you looking? Old man, who is? No, that's not all. No, I don't know.
Then PW
No, who has identified this old man?
Pratap Paul, PW2 and even this PW8. When I was about this one, PW8 Lordship, he deposes. When I was about to enter the shop, Pratap Paul and his wife assaulted me with lathi.
Wife.
Yes. Pratap Paul and his wife.
Oh, and
Thereafter, I entered Giri Biswasov. Thereafter, a commotion took place outside. Pratap Paul and his wife entered Giri Biswas's shop, and when they attempted to assault me, Rita Das saved me from them. One of the other eyewitnesses.
assaulted with what?
Stick.
Stick, not spear.
Not spear.
Not spear.
Let us see the other witness whether it's spear or not. How 80-year-old man hitting with a lathi, it will not.
No, that time, my lord, date of occurrence is, my lord, 2001.
One.
That time, yes.
Present age is 84, my lord. That's why I say, my lord, like small kids like juvenile, but for old person above 80, there is no law. But medical terminology says they are garretic person, my lord, cannot take care of themselves, 80 plus. So there is no law for that also. If a person is garretic, my lord, some law should come in.
This PW8 is the injured eyewitness. He talks about Porimal, the Pratap. As Pratapal assaulted me on my head with bamboo lathi. I sustained injury in my head.
He didn't die, no?
No.
He's 86 now, he's too old
The time it will be.
to be in jail.
They're languishing in jail, Nikki.
At that
Oh,
time
he's
also he
too
was
old
a
to be in
senior
jail.
citizen.
But applications should come up from them. But no
Application is here. This is here.
Mm.
This 313 of 2021 is here.
Bail to us.
This is item 10.
I
313. Your written objection is also here.
all is there, except the order, my lord.
Not the order. May I
They've been
take a
in.
report from the jail authorities as
Why
regards
more?
bail
Why-
condition?
No, he's
Coming out
old.
from 13, it will come, no?
The judgment was passed when in 2016.
Mm.
Then he's been in jail since then.
Yeah.
Or what? So it's 2016. Now nearly 10 years. Old man.
9 years.
Oh, it will, okay, it will.
Pratap, let us see his age in 313, my lord.
Yes.
You can just.
Pratap,
Thank you, ma'am.
18.
Mm.
Leave it.
He'll be no harm to anybody now.
Now he will not venture it for the second time to kill somebody, my lord. Too old.
Who does it, Pratap?
Mm.
Lordship, today, my learned friends, sarcasm, it's like, it's in favor. My learned friends.
Why?
Pratapal is his client and the other one on juvenility point it will be released.
Acha. Oh, so
He's favoring him.
no, he's an old man now.
Yes, ma'am.
Leave it to
But
Because at
he-
page 94, it is written in 313 at that time
80
itself,
years.
he was
80
80
years.
years, man.
That was which year?
2014, man.
14,
80 in 2014.
14.
So he'll be 91 now.
Now.
91.
as per records.
Ah,
Huh?
legal
Leader, lordship, he is leader of all the accused now.
is. So somehow he's surviving.
And the age is his factor. My lord.
I think. How can he do it?
Bail to the ako huma.
Okay, right. Heard Mr. Z Kamat, Leonard, Senior Counsel for the applicant Sri Pratap Paul and Sri Parimal Paul. He submits that the applicant Pratap Paul is 86, was 86 years of age at the time of filing of the present interlocutory application number 313 of 2021. He accordingly submits that the sentence inflicted upon the applicant under section 302/34 IPC pursuant to the judgment and order dated 11/1/2016 passed by the Court of the Learned Additional Session Court Judge number 2, Kamrup M. Wadu, should be suspended and the applicant Pratap Paul should be released on bail. He also submits that the other applicant, Sri Parimal Paul, has been declared to be a juvenile by this court in terms of the juvenility report submitted by the Court of the Additional Sessions Judge number 2, Kamrup M. Wadu. First, in terms of section 94 of the JJ Act 2050, pursuant to an ossification test done. He accordingly submits that as the applicant number 1 Pratap Paul is approximately 91 years as on age, the applicant should be released on bail. In terms of the NARSA scheme for grant of bail to old person. Next, Ms. P. Buyan, Leonard Addition PP, submits that you strongly object, don't object much, or leave it up to the court, or what?
I leave it to up to the court because of his age, my lord.
Submits that she leaves it.
But I'm not concede, my lord.
She leaves it to the wisdom of the court to decide as to whether the applicant number 1 should be released on bail. Keeping in view his age. So, on considering the age of the applicant Pratap Paul to be approximately 91 years of age.
And he's behind the bus for last 10 years.
And as he has been behind, as he has been in judicial custody for the last 9 years.
9 years, yes.
We are of the view that the applicant should be released on bail. Applicant Pratap Paul, accordingly. Applicant Pratap Paul is released on a bail bond of rupees
50,000?
50,000 with one surety of like amount to the satisfaction of the Learned Additional Sessions Judge Kamrup Metro. What?
Additional sessions, just there are 5, my lord. Then 2 is the trial court.
That's what I said, 2.
FTC.
The applications accordingly disposed of.
Much obliged. Thank you.
Bail petition given and
May I please, your lordship, that paper book is there, my lord. I'm pressing the IA, my lord. Your lordship may go through the my lord, FIR and the evidence of prosecutrix and her accompanied, perhaps your lordship will satisfy that it is a case of granting or suspension of sentence, my lord.
Also case.
Yes, even if POXO,